So you got a motion and a second. You have House Amendment 4305, sir.
Yes, sir.
Members, you got a motion and a second on the amendment. Members, do we have any objection to adopting House Amendment 4305 to House Bill 1131? All right, seeing none. All those in favor vote aye. Aye. Opposed, vote no. Ayes have it. Now we're back on the bill as amended, sir.
Thank you, Mr. Chair, and thank you, committee. And members, I ask that you remain open in this discussion, and I further ask that you see this discussion from the lens of a child who has absolutely no responsibility regarding what the adults are arguing about, but the children are the victims here. Think about this. Simply because the adults have dissolved or are dissolving their relationship, it does not abate the relationship that the child has with his or her mother or his or her father. God gave a child two parents, and they need both in most cases for balance. When we as a society remove one of the child's parents from the child's life, we take the child out of his or her natural balance. It is the child's God-given right to have access to both parents whenever possible. We know that there's been a tremendous lobbying effort by the Bar Association, who I respect. Their family court division is against this bill. However, I asked the trial lawyers their thoughts on it. They had no issue. I also called and have spoken to several judges across the state, both rural and urban, from across the state, and every judge that I spoke to said this bill in no way binds their hands in regards to outcomes. In fact, this bill actually frees them up to look at the entire picture that speaks to the best interests of the child. And that's what we're here for. The question is, what is in the best interest of the child? I submit to you that a child has the right to both his or her parents, and that is by far, from the standpoint of the child, is in his or her best interest whenever possible. That's the key, whenever possible. While this bill is not a fix-all, it is simply a start with an important declaration. That declaration says it is in the best interest of the child to have both parents involved in the child's life when possible. For decades, through policy at the federal level and at the state level, these policies have been levied and have destroyed the family structure in our country and in our state. An example of that is the federal welfare laws that came from the 50s, 60s, and 70s that said if a woman receives assistance from the federal government, then the father could not be present in that household. The state would then follow suit, forming and supporting those ideas, and kept some parents out of the life of the child. I ask you to look at the outcomes that these older policies have delivered in our society. Look at the state of our youth. Look at the youth violence numbers and the egregious levels and types of violent acts and crimes being perpetuated by our youth. Look at the elevated levels of trauma. Look at the elevated levels of mental health issues in our youth. Look at the lifestyle choices, joining gangs, etc. What this bill does, it simply says that, one, it establishes a rebuttable presumption that joint legal custody and equally shared parenting time are in the best interest of the child. Now let's define rebuttable presumption. A rebuttable presumption, based on the definition that legal gave me, and if we want to go out of session to legal to say it themselves, you'd rather take their word for it, I'm okay. A rebuttable presumption is simply a starting place absent evidence. Let me say that again. This is important, a rebuttable presumption is a starting place absent any evidence. So what that looks like for those of us that are visible, before the parties come before the judge or the courts, everything is in the middle. Once the parties come before the courts, evidence is presented, the judge has all discretion based on that evidence presented to go to one parent or the other, or to go in the middle, up or down, whatever that judge decides. We are not binding the judges. We are, and I'll say it again, and I've spoken to the judges, and this is what they've told me, rural and urban judges alike across this state. This legislation in no means binds us in regards to our outcomes. What this bill does is it establishes parenting time and joint legal custody as a starting point. That's it.
All right. Thanks, sir. That's your 5 minutes. Members, any questions for the sponsor? We do have some folks signed up to testify. Representative Garrett, you're recognized.
Mr. Chairman, I don't want to, if there's folks to testify, I'd rather hear from them first. If they're going to testify anyway, then I've got may have some questions for them as well.
That's right. Yeah, I had Representative Parkinson indicated we have four folks that he'd like to bring up, testify in support of, and then we have 2 folks to testify in opposition. So, members, we want to go to session and hear from our guests. Any objection? All right. If we could bring up Mr. Music and then Mr. Spanos. Blake, I'm sorry. Yes, my bad. I apologize. All right, cool. Ms. Music, we'll start with you, and then Mr. Spanos will. So y'all have your mics will pop on. If you would, just introduce yourself. Red light will come on. You have 2 minutes apiece.
Okay.
Thank you.
Thank you, Tennessee House Judiciary Committee, for your time. My name is Dr. Vargas Music, and I am speaking for the Tennessee Safe Parents Organization, which represents 500 mothers and fathers across Tennessee. First, I would like to point out that this bill's caption did not include any wording about custody arrangements. The caption text was about child support, and the amendments still have not been posted on the Tennessee government website. The manner in which this bill has been presented violates the rights of the Tennesseans, since we cannot know about it or have access to the wording that is being heard today. Moving on to the bill, TSPO asserts that the best scenario for children is equal access to healthy parents. 9% of cases that go to court are shown to involve domestic violence and child abuse. However, there is an alarming trend facing parents in this state and in our nation called parental alienation. This term was coined by a man who used the concept as a way to counteract claims of abuse. The concept of parental alienation has put family law into a frenzy. You will hear from court professionals like William Bernay, who use this term in custody evaluations to force children into reunification programs where children are traumatized and compelled to recant allegations of abuse. According to research published in the Journal of Family Violence, these custody evaluators, including Bernay, may have financial ties to these programs, such as the one called Turning Point, which children in Tennessee are ordered to. Sitting in the front row behind me are 2 little girls. The older girl was severely abused, and I cannot say what kind, but you can imagine. DCS substantiated the abuse. However, because the father claimed parental alienation, the court ordered the girls into reunification therapy despite the protests of DCS, the Children's Advocacy Center, and the children's pediatrician. In my case, restraining orders, medical neglect, child abuse, domestic violence, and my child's PTSD were all ignored by the courts. Tennessee Safe Parents Organization is asking that this honorable committee require sponsors of this bill to bring our organization to amend this bill. Specifically, we propose language that allows for evidence of abuse to a parent, other person, child, or other siblings to be guaranteed entry into any custody case, addressing the res judicata legal argument that currently prevents evidence of abuse from being entered and applied. We request that this bill be rewritten with DCS, TBA, TSPO, and the Tennessee Coalition for Domestic Violence.
Oh, thank you, ma'am. You're right on time there. Sir, if you would introduce yourself, you have 2 minutes.
My name is George Spanos. I am the chair of the Tennessee Bar Association's Family Law Executive Committee. My practice is entirely focused on family law, and I am a certified family law advocate here in Tennessee. I have spoken with over 100 different attorneys who practice family law across the state, from Memphis to Knoxville to Chattanooga. I've talked to judges across the state. Not a single person has told me they support this bill. Every person is objecting to it. This bill causes significant problems in family law. The presumption that's being put in place will cause detrimental effects to how cases are tried, and we've seen this evidenced in other states, most notably Kentucky, who I've looked up their information because they have it all posted through their administrative offices of the courts. Our fears are that the same thing will happen here that happened in Kentucky, that divorces will decrease, parents will, on both sides, mothers and fathers, will be concerned about divorcing and having another parent have a 50-50 parenting time when they are in situations of abuse. If you look in Kentucky statistics, this is what happened. Orders of protection, domestic violence, and similar filings exponentially increased over a 6-year period, some of them over 100%, never to come back down, others up to 88%. This bill will cut the legs out of the best interest calculation because this bill presumes that the best interest is already been found. If it did not do that, it would not require findings of facts by judges to explain why they did not do 50-50 with equal parenting time, but require no findings of facts to do 50-50. This is a one-size-fits-all solution to probably the most important factual determination a judge can make in a custody case. What is the best interest of the child? The current standard is appropriate. We start with a blank slate. By law, gender cannot be a basis for parenting. By law, already, the courts are to maximize each parent's parenting time with the minor children. This is already in place. If the intent is to make sure people are treated fairly and equally, our laws are doing that now, and the facts to each case, to each child, are what the courts analyze.
Very good. Thank you. Your time's up.
Thank you.
Members, any questions for our guests? Representative Johnson, you're recognized.
Yes, and thank you so much. I like the way you said start with a blank slate, because I think that the consideration here should be in the child's best interest. And if you start on a presumption of 50-50, then you're not considering the child's best interest. And so I think that that is a really important statement. Certainly, we want a child to have access to both parents, but if in situations like we know happen, we're presuming everything is okay. And to make somebody prove that it's not initially in custody, to me, is problematic. I think that it should be a blank slate, and we should always start first with considering what the children need. And so I appreciate that. And what you were saying about Kentucky, so what you were saying was that this type of legislation or this legislation caused people to stay married who were in abusive situations, whether it was a spouse that was being abused or a child that was being abused. But for fear of losing custody because of that 50-50, or at least their child being with a dangerous person 50% of the time, they chose to stay in abusive relationships. Was that the result that you talked about?
Can I speak on that?
Yes, but let me
Okay.
ask him first, and then we'll let you do that as well.
Looking at the data, that's what it would indicate. Also from personal experience in family law, these are things that people tell me already. When I see abused spouses, abused children, parents are already afraid of going into the system and creating a situation where they're not with their child at all times, whether they were the abused person or the child was, because they will no longer be there to either protect the child, or their fear the child will be abused or be the instrument of further abuse to them. And that fear is very palpable, and it already exists with people today. I've met with people who I've had to tell, you need to file because you're not safe. And I only do that when it's physical abuse or something worse. And I don't have to say it often, but I already have to tell people that. And it's very disheartening, it's sad, and it's difficult. And people will be, I'm afraid, more concerned with this, and that's what my peers agree with. They are very concerned with this bill. I can tell you from experience that an attorney told me specifically that she would not have filed for divorce if this bill was in place, because she would not put her children at risk for this very reason. Thank you.
Thank you. And you might have some personal experience.
So I addressed the term parental alienation. There have been multiple studies over the last 10 to 15 years that show men use this term. I say men. Men are also abused. However, we know that 85% of domestic violence is against women. So when I say the women, I mean both, but primarily women. Mm-hmm. When men use parental alienation as a counterclaim to domestic violence or child abuse, Studies show that they get custody in 73% of cases. Common sense tells us that our courts are protecting our children, right? We have this, we're saying, oh yeah, we can deviate. That is not what the courts are doing.
Okay. And you also mentioned something about some of information being prevented from being presented.
When I started my case, I had a restraining order. My daughter had multiple custody evaluations by a child psychiatrist who was able to tell in her play therapy that she had witnessed domestic abuse, was likely sexually abused, and this was substantiated. Mm-hmm. She went to the Children's Advocacy Center and later a therapist. Over the course of 6 years, 3 different independent psychiatrists and therapists had come to the same conclusion. In my case, she said she wanted to die because she did not want to go to her dad's house. I brought this to the judge. The judge awarded my ex-husband 50-50 custody in a Zoom hearing that I was not allowed to attend.
Thank you.
Members, any additional questions for our guests? All right, Representative Powell.
I guess, ma'am, if you could tell me, since this happened under the current law, like what sort of steps would you recommend? Or, I mean, if this did happen under current law, what do you see as like a adequate solution?
Are you speaking to me or to?
To you. I'm sorry. Yes, ma'am.
An adequate solution?
Yeah.
First, we are asking that parental alienation be removed from being allowed to be used in the court system. They also use terms such as gatekeeping and enmeshment. We would also like to limit reunification camps, which is another thing that they send children to. A reunification camp is they send these children to camps with their abuser. They say that's a fun wilderness camp. These kids have come out of there saying that they are essentially put into jail cells. They are not allowed food, water, and they have to sleep in their own feces and urine until they say that they have not been abused. Then they have this in recordings and use this in court testimonies. So we would like to remove the use of reunification camps, reunification therapy. In the case of the girls behind me, she has been in a case for 5 years and she has substantiated abuse. And the judge continues to order the children to reunification therapy with their father. And these girls are terrified. We want to see reunification completely removed from this state. We also want to make sure that all judges, court professionals, attorneys, GALs are appropriately educated. And we also want to make it clear that we are for shared parenting. This is an unintended consequence of setting the bar at 50-50 because it is already so hard for us to prove, and not even prove, I mean, I had proof. I had police reports. I had restraining orders. The courts are not listening to it. So how do we make our judges obey the law? I can't tell you because when I tried to file an appeal against my judge, I was told that it would take a year and it would go right back to the same judge. So how do I feel comfortable filing an appeal against my judge for improper conduct knowing that it's going to go right back to him?
All right. Members, any additional questions for our guests? We do have 4 more that we need to pull up here. We're running short on time as well. So any additional questions for the guests we have up here? All right. Seeing none. Thank you all so much.
Thank you.
Members, if we could have Mr. Harvey, Mr. Mr. Ludwig, and Mr. Burnett. All right. Gentlemen, just have a seat anywhere you looks comfortable to you, and then we'll start with you, sir, on my left. We'll start with you. If you would just introduce yourself. Each of you, your mic's on right now. You have 2 minutes to introduce yourself, and you got 2 minutes. Each of you all will have 2 minutes to speak. So go ahead.
Okay, thank you. Members of the committee, my name is Mark Ludwig. I'm an Uber driver from St. Louis who my story ended up going viral. I was relegated to basically an every other weekend father after having an extensive background working with special needs kids, foster kids, and teaching kids in my church. I was pretty well known in the St. Louis area. My story went viral. It had over 120 million hits. So I've got over 1 million followers on social media, obviously not because of me, but because the story resonates. Half of all marriages end up in divorce. Half of all kids are born out of wedlock, and we have a lot of broken homes around the country. And what happens to a child is they have the dual trauma. Trauma number one, mom and dad aren't together. They don't understand that, but they're confused by that. Now trauma number two, why is one parent the inferior parent and one is the superior parent? Why does one parent have to beg for permission to get extra time? Why is one parent always here? And the challenge with that is when you get into the teenage years, when that child starts having behavioral problems, it's very hard to discipline a child when that child has been raised to believe that this parent is inferior, and all of a sudden, oops, we need them back in the life now that they're a teenager. And that's why we wind up with so many problems all around the country with behavioral problems, drug abuse problems, incarceration rates, violent crime rates, high school dropout rates. The one common ingredient, they grew up without a parent. Now, it's usually the father, but I'll fight just as hard for a mother because I'm not fighting for the mother or the father. I'm fighting for the child. And unfortunately, we have a system right now that focuses on the parent. It's one parent fighting against each other. If instead we could focus on the child and say, wait a minute, that child needs both parents. Each parent adds value in a different way. And so what happens right now, I get a lot of my followers that say, Mark, I didn't have near as much animosity to the other parent until I walked into my family law attorney and they said, look, in our state, you're not going to get 50-50. So I need you to dig up dirt on why you're the better parent. I don't think there is a better parent. Maybe different parenting styles, but that's why I think it was designed. And could you imagine how different it would be if that same parent would walk into a family law attorney's office and they'd say, you know what? In our state, unless you've got some abuse or some overriding reasons to not do 50-50, you better learn how to co-parent and get along, put that money in your own kid's college fund instead of my college fund, and clear the courtrooms of 90% of the cases that shouldn't be.
All right, thanks, sir. You're 2 minutes up. Sorry, you're up now. You're 2 minutes up. We'll have time for questions.
All
Sir,
right.
if you'll just introduce yourself, you'll have 2 minutes as well.
Good afternoon, esteemed members of Tennessee State Judiciary Committee. My name is Antonio Harvey, and I stand before you today as a father and a current school administrator in Memphis Shelby County School, who has been dedicated my whole life to supporting children, over 300 of them every day at my school. Yes, despite my commitment to nurturing young lives, I was denied 50-50 custody of my own children. I'm here to urge you to pass the House Bill 1131, not just for me, but for every child in Tennessee who deserves equal time with both parents. As a father, I know how much kids light up when they spend time together, whether I'm helping them with their homework, cheering them on in their games, or just listening to their hopes over a quiet evening. As a school administrator, I see this multiplied across hundreds of students. Kids with involved parents, I mean both parents, consistently show better grades, fewer behavioral struggles, and stronger emotional health. Presumptive 50-50 custody isn't about parental rights. It's about giving our children a chance to thrive with a full support of mom and dad. Childhood is built on memories, fishing trips with dad, baking cookies with mom, the little things that become big memories. For my own children, I fought to be more than a weekend visitor because I know their experiences require time and presence. When the law doesn't start with equality, it risks stripping kids of half of their story. I want my kids to remember both parents tucking them into bed, both teaching them how to read, how to ride a bike, and that balance fosters security and trust, things every child needs to grow strong. I work with children every day, and I see their potential, their struggles, and their joys. I was trusted to guide and support over 300 students every day, yet I wasn't trusted with equal time to raise my own children. That's a disconnect that we can fix. Yes, there are cases where 50-50 custody isn't safe or feasible. I trust our courts to handle those cases wisely. But starting with presumptive...
Thank you, sir. Your time's up, and we'll have time for questions. Sir? Your mic's on. You can introduce yourself there, and we have 2 minutes. Thank you.
Chairman, committee, I don't have anything written. I speak from the heart. I listen to the folks behind me. They have valid points. There's always going to be insinuating circumstances, always. I came from a divorced parents in Kentucky, where I'm from. My mom, my stepdad, and my dad got along great, shared me. Everything was fine. Later on, I got married, got a divorce. We didn't go out to dinner together, but we raised our children together. I had no qualms about her new boyfriend or new husband, and I see it every day. But I'll tell you one thing that really, and the gentleman brought it up, I actually was the president of the basketball league in Laverne. I coached football and baseball for 20-some years, and from 5 till 18. And when I would see them little fellas running off that field or off that court with sweat beads coming down their face, smiling, and then I'd look up at game time and they wouldn't be there. What's going on? Well, it's his mother's weekend, or it's his father's weekend. They would not do it together. Now I don't know what the reason, but what I do know is things change. Me and my ex-wife, we did a 50-50. That every other weekend nonsense, let's be realistic, let's call it what it is. As a child, if you loved your mom or your dad and you only got to see them every 12, 14 days, think about that. Those of you who have parents still living, do you feel comfortable about not seeing them every other week? Now, like I said, there is circumstances. That's up to the court, so that's not up to this body.
Thank you, sir. Your 2 minutes up. We'll have time for questions. Sir, if you would go ahead and introduce yourself, your mic it's on now. So if you'd be sure to introduce yourself.
Yeah, hi, thank you, Mr. Chairman and committee. I'm Dr. Bill Burnett. I am a child psychiatrist and forensic psychiatrist, was on the faculty at Vanderbilt for 20 years. I'm retired, so they made me an emeritus professor of psychiatry at the medical school. So actually, one of the previous witnesses mentioned me because of my interest in parental alienation, which is fine, but I'll just point out that as far as I can tell, parental alienation and also reunification programs don't have anything to do with this current bill. That was just totally extraneous information. I want to summarize for you why I'm in favor of this bill, and it's not my opinion, it's not off the top of my head. It has to do with what is the research. There's been 30 or 40 years of research on shared parenting, and it shows the following. First of all, children of divorced parents raised in shared parenting arrangements do as well or better than other children of divorce, especially in terms of how they have relationships. When I say research, these are big studies. They're huge. Some of these studies involve 100,000 children, some of whom are in shared parenting, some of whom are in different arrangements. It's a basic premise. We all believe that it's advantageous for children to have healthy relationships with both parents. The research shows that children raised in shared parenting have better and more enduring relationships with their mothers and their fathers. You can study this. I can explain to you how they do those studies to show that. Now, it's interesting that for children to benefit from shared parenting, it's not required for the parents to agree or to be totally non-hostile or to think it's a good idea. That's another thing that's been shown in research, that even when parents don't agree in the beginning, that as the shared parenting progresses, there's more and more agreement, there's less anger, there's less hostility, and there's less returning to court. Now, I'm not saying that violent people should be given shared parenting. I'm not saying that.
Thank you, sir. Your 2 minutes up. We'll have time for questions. Representative Hardaway, you're first on the list.
Thank you, Chairman. First, I was interested, I was captivated by Mr. Harvey's story. Can you finish out what you were sharing?
Yes, sir. at the end, I was saying that I trust that our courts can handle this wisely by starting up presumptive equality. Tells kids that you get both of us, you have a chance to, you don't have to choose, and it reduces conflicts by easing the burden on families and courts. And then I said that Tennessee can lead by valuing both parents' roles and creating positive childhood experiences and passing presumptive 50-50 custody for children, which I have served 300 daily, is for every child who deserves a full, balanced story in their lives. And that's what I was talking about and everything. And so I think that it's very important that we focus on the children, looking at what's creates positive child experiences. We oftentimes hear about the adverse child experiences, but we don't talk much about what creates the positive child experiences. And so when you think about it from my professional lens as an educator, when we see those parents that are actually working together and have time together with their children, then it creates an environment where the children can thrive. And I know that everybody wants our children to thrive in our community, and we know that when you have both parents equally involved in their lives, it's very important. And then, as this gentleman said, when you think about basically the shared visitation, I don't know if people really understand, that's basically 4 days a month that you have to actually work with your children. And I don't know if that's really a great number to actually support a child 4 days in a month. I think, we get the notion of every other weekend, but there's only 4 days a month that you actually work with your children and everything. So I think we need to really focus on providing positive childhood experiences for our children.
All right. Thank you. And till the lawyer, I can't remember your name.
I'm an Uber driver, not a lawyer, but.
Oh. All right, I'm going to ask you anyway. Are you familiar with the process for developing parenting plans?
There's several
and do
different.
you have an opinion about how this would impact that process?
There's several options. They could do like a week on, a week off. I know there's a couple in the audience here that does a 5-5-2-2 plan. There's a bunch of different options, and that's something that's pretty much determined between the judge and the two parents to figure out what's. But I think the most important thing is to say, wait a minute, the child needs both influences. Now we need to figure out how to make it work. And that's why I said it needs to be about the child. The parents need to be able to figure out how to make that schedule work.
All right. Thank you. Thank you, Mr. Chairman.
Thank you, sir. Representative Garrett, you're next on the list.
Thank you, Mr. Chairman. I move for us to go back into session.
Very good. Any objection? Seeing none. All those in favor of going back to session, say aye. Aye. Opposed, say no. Aye. Ayes have it. Thank you all for being here today. We're back on the bill with the sponsor, so we really appreciate your time. Thank you so much. Members, any questions for Representative Parkinson? Representative Garrett, you recognize?
Thank you, Mr. Chairman. I don't know how much time we have, but I've got quite a bit to address on this particular piece of legislation. I've talked to the sponsor. We've already had some heated discussions, I would say, maybe on my end more than on his. Fair enough. On this particular piece of legislation, as the committee knows, I practice law. I've been a lawyer. I've done family law. I've done divorces. I've done mediations. I've done child custody issues for my entire career as a lawyer. And I have some grave concerns about this piece of legislation. Let me kind of describe why. We heard a lot there from the witnesses. One witness had a custody case in another state, had nothing to do with the laws of the state of Tennessee, and I'm sure what happened to him in Illinois was a lot different than what's happening here. We had one expert talk about shared parenting, and shared parenting is absolutely doesn't mean 50-50 as it relates to what shared parenting does. We already have shared parenting here. In fact, our statute, the lawyer with the Tennessee Bar Association's family laws practice said that right now we currently our judges are required to maximize the parenting time in a divorce setting for the parents. Let's not take the extreme cases, what that means, right? The ones that we're talking about being an abusive parent, that oftentimes the parents are the one abusing the children. And in this instance, for a 50-50, you're automatically giving them credit for being a 50% great parent. And although I don't agree too often with my friend from Knoxville, Representative Johnson, I absolutely 100% agree with her statement. She asked to one of the folks that testified earlier is that you're elevating the importance of the parent rather than elevating, which the Tennessee does currently, the best interest of our children. And so when we have something that's not the extreme, which in this role that we play, sometimes we do things for the extreme to make a point. I'm not going to go there. I'm simply going to say, what if you have an absent father? What if you have an absent mother that cannot determine where the next visit for the pediatrician's office, what appointment they have for their annual well exam, can't even name their pediatrician? That's many things I do in the deposition with someone is ask these very basic information about what parents typically do. And when that parent can't answer those things, when they can't determine and have a relationship with their parent, they don't go to their Little League baseball games, they don't go to their dance recitals, they don't show up. These are all factors that we consider on whether or not they're a good parent, right? All of us can be fathers for the most part. All of us can be mothers for the most parts, but it's harder. It's a challenge to be a mom and to be a dad. There's a difference. And so when we tell a judge that they've got to give someone that does not go to any baseball games, that does not go to any dance recitals, that doesn't care what their kids are, doesn't even know what their grades are when their report cards come out, we're going to give that parent automatic 50%. Boy, you're halfway there. You are halfway a great parent, and we're making these judges make that determination on the onset. And that's bad policy, Representative Parkinson. That's what this bill is going to create. One other thing that it's going to do is that typically the major things that people fight about, and unfortunately these are some of the worst circumstances that you can possibly have when people want to divorce and basically dissolve a family. Then you're going to have two households, two places to go, right? That's a terrible position to be in. 80 to 85, maybe even more % of these cases, divorces and child custody cases settle. That's historical, right? They go and settle. The parents find a way to resolve their differences for the best interest of their children. Most of the time, not for themselves. What we're going to create now is that when you run the child support calculator, that's based upon income and that's based upon days spent with the child. It's always, 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 always going to be ran on a 50-50 basis if this bill passes. That is a substantial difference in what a child support order would be based upon a 50-50 scenario rather than what is practical, what a judge can determine on the facts before them, on the cases that go to trial. By the way, they're the worst cases. These are the cases the parents cannot agree. The parents don't know how to parent. Their children are desperate for their parents just to be parents. They're the ones going to trial. The worst cases you can think of is what our judges have to determine, and we're going to say both of them are equal footing. I would go further to echo my friend from Knoxville and say they should start at 0%. They should come busting down through the courtroom door and say to that judge how good of a parent they are, that I want 100%, but they got to start at 0. They don't start at 50%. That is impossible. That's detrimental, I think, to giving the discretion the judges need to view each case separately. We heard 5 or 6 different stories about the folks that testified. Each case is different, each case is specific, and each case is unique. And that judge has to have the tools to not start at a 50% for each parent when one parent doesn't even know the middle name of their kids, much less in an abusive relationship. That's what this piece of legislation, Representative Parkinson, is going to do. One thing that also concerns me, and then I'll be glad to hear from others. I know I've taken a lot of the time, and I appreciate the chairman giving me a long leash on this, is that to modify a parenting plan, you've got to prove a material change in circumstance. You are about to do that with this bill. Every single custody order or permanent parenting plan that's in place, this statute's going to allow the parent that has the children less to come back to court and say, I get 50%. So we're going to open up the floodgates for folks to come back, relitigate their cases, because now they see a statute that could allow them and guarantee them 50% whether or not they care to see their children or not. That's what this piece of legislation does, committee. That's what this piece of legislation bothers me. That this piece of legislation is bad policy, and that's why I cannot vote for it. And I hope you all see that this legislation is not good for the best interest of our children, not the best interest of their parents. Thank you, Mr. Chairman.
Mr. Chair, can I respond? Do you mind?
Representative Parkinson, you recognize.
Thank you, sir. Chairman Garrett, I truly appreciate your experience and your insight and you know the things that you're bringing up. I think it's important to note that we're not putting parents on equal footing here. We're simply setting a starting place. All of the scenarios that you spoke of is that evidence that is absent based on the presumption. So again, let me go back to the definition of the presumption. It is a presumption, a rebuttable presumption. That means this is where we start, absent the evidence. So if there's evidence that this father is abusive or this other parent is abusive, right? That removes the presumption. Now, and that gives the judge the full discretion to grant that living arrangement or whatever the judge decides to do for that child, right? The other thing is this. I'm not, with this legislation, we're not expecting 100% 50-50 outcomes. That's not realistic for us. That's not even what we're attempting to do. All we are attempting to do is set a starting place. Let me give you an example of what it could. Well, we've heard a lot of testimony based on current law, and it wasn't great testimony. But what happens if it is an elected official fighting for custody of his child? And we know we might not have the specific relationship or be, personal pals with a judge, but it's not far-fetched that the judge could lean that way under current law right now, right? Because we know that it is a fact in most cases today that the judge tends to lean towards the mother, right? And that's fine. And under this law, the judge can still deviate from that center based on, but we're asking for here, present the evidence. And one thing that I hope that we'll all consider and take exception for is the majority of fathers want to be in the lives of their children. The majority, in fact, I would say the overwhelming majority. But we are in here painting a picture of non-custodial parents as if they are abusers based on an accusation. But when the judge hears the evidence of that abuse, the judge has the full discretion to move from the center. So this is not a bill that I think that and every testimony is incredibly important. Let me preface with this. And to the young lady and her daughter, my heart goes out to you, and we definitely don't want those situations. But that is not the majority of situations. That is not the majority. 20% of marriages end in divorce based on abuse. 80% don't. Parenting plans, when couples go through a divorce, they're the only ones that have to, for the most part, present a parenting plan. It's the divorces. When they go through the divorce, the judge can absolutely accept that parenting plan under this legislation. He can accept it, whatever they decide. And so in cases where they are not married, you had a child out of wedlock, and these individuals are coming before the judge starts in the middle, and he can deviate as soon as they tell him what's going on in these households. So I apologize if I'm not fully, understanding the argument here. So, and I apologize.
Thanks, sir. Leader Lambert, I have you on the list next.
Move previous question.
Very good. Previous question has been called. Any objection? All right. Seeing none, members, looks like we're ready to vote to send House Bill 1131 to
Can I have a closing statement, Mr. Chair?
counter and rules. You just did. Members, all those in favor of moving House Bill 1131 as amended to counter rules, vote yes. Opposed, vote no. All right, members, everybody voted. Any member wish to change their vote? All right. Madam Clerk, take the vote.
Mr. Chair, you have 3 ayes, 16 noes, and 2 present not voting.
House Bill 1131 fails.
Thank you. Thank you.